Hello everybody. Today we're going to talk about case law. Specifically, we're going to cover exactly what is case law, how you find cases efficiently, and how you ensure that the cases that you rely on are still good law before you cite them to a court, a client, or a senior lawyer at your firm. In a common law jurisdiction like we have in the United States, reports of judicial decisions are among the most important sources that we have of legal authority. While common law jurisdictions do rely on some codes or statutes, the code's not comprehensive, and the outcome of many judicial decisions relies solely on examining precedent, which is the judicial decisions that have already been made in similar cases. So you can see that in common law jurisdictions, judges actually have the power to create and shape law rather than merely interpret law that has been created by another branch of government. Contrast that common law jurisdiction, such as the United States or UK, with a civil law jurisdiction such as France. Civil law jurisdictions have comprehensive, continuously updated legal codes that specify virtually all matters that are capable of being brought before a court. Judges in civil law jurisdictions must work within this stringent format. And so, within that kind of a system, the judiciary has virtually no role in actually creating the law. All right, I think that's enough background about what a common law system is. Now let's move on to talking about what is it that courts do and what is the purpose of case law. So we've touched on this a little bit already. It's kind of broken down into three major categories, what courts do. The first one is determining the constitutionality of a statute, and that's usually done at the federal level by the Supreme Court or in New York by the Court of Appeals. Courts also interpret statutes. It's not so clear, often particularly to opposing parties, what the statutory language is supposed to mean, and a court will step in and decide that in litigation. And then very often courts also hear cases that involve no statutes whatsoever. It could be a purely common law issue like tort or contract, and the court will come in and tell the parties how the common law principles apply and end up making a decision completely in the absence of any statutory language. So that's what courts do, and why does case law matter? Common law jurisdiction, it's clear that it matters because of stare decisis, which means that courts are bound by earlier decisions. In the American judicial system, we have a hierarchical structure for our courts. So the precedential value of a decision is determined in large part by the court's place in the hierarchy. So decisions from a higher court, for example, in New York, the Court of Appeals, which is our highest court, is binding or mandatory authority, and it has to be followed by lower courts in the same jurisdiction. So basically in New York, every New York court is bound by the decisions of the New York Court of Appeals. Decisions from lower courts or courts in other jurisdictions are not binding, even if one of those courts has considered a situation that's similar to the issue in the present case. That is merely considered persuasive authority. So in short, it's something that the court should consider in its analysis, but it need not follow if it chooses not to. And there's other ways that courts sort of can soften this concept of stare decisis. If it feels like it doesn't want to follow a case, it can differentiate the present case on facts or the law. Alternatively, appellate courts can overturn lower court cases or their own cases. And it's just important to understand, why do we have this concept of stare decisis in our common law system? And it's really based on the concept of fairness. There's a belief that decisions should be consistent so that the legal consequence of your conduct can be predicted. So if I go through a red light and I face a certain consequence, the same thing should happen to you, and you should be able to predict that by looking at former court decisions. Precedent also explains why all attorneys need to search for and be familiar with all prior relevant cases in their jurisdiction when they're preparing for court. Even if you find a decision that goes against you and it looks like it's bad for your client, you need to be aware of it because you need to deal with it in your arguments before the court. You need to say why it differs factually or why the legal jurisprudence has evolved. But either way, you need to be aware of it. That's why we're going to spend the rest of the class talking about how do you find cases and how do you apply them. All right, let's just spend a minute talking about the process of litigation and a little bit more about this hierarchical system that we have here in our U.S. judiciary. So as you know, litigation usually begins in a trial court, and this is the lowest level of the court hierarchy. In the trial court, issues of fact, for example, was the beware of dog sign posted or not? These kind of factual issues are decided by the fact finder, and that's either going to be a judge or a jury. Factual findings are binding on the parties and they cannot be appealed. Issues of law, to take that same example, did the beware of dog sign limit the owner's liability for injuries, are decided by the judge. And if one of the parties disagrees with the judge's rulings, they can appeal that to a higher court. So appeals from a trial court are generally taken to an intermediate appellate court. You can see the federal structure here on the slide. And then usually after that, there's a court of last resort in each jurisdiction. So in New York, this is going to be the Court of Appeals. I'll show you the New York court structure in a minute. And at the federal level, it's the Supreme Court. Most courts of last resort have discretion on whether or not they want to hear an appeal. They don't have to hear it. And it is true that they do refuse to hear most disputes. So most cases that are appealed to the Court of Appeals or to the Supreme Court, the court will refuse to hear them. They only take a small portion. And that's true because the role of these courts is not to resolve every individual dispute. That's left to the trial and the intermediate courts. Instead, these high courts are meant to establish legal doctrines and to interpret legislation and administrative acts like regulations, and to resolve disputes amongst the intermediate appellate courts. You've heard at the federal level about a circuit split. That's kind of what one of the main jobs of the Supreme Court is. And keep in mind that a court of last resort's decisions are binding on all courts within its jurisdiction. This means that every U.S. court is bound by Supreme Court opinions, and every New York court is bound by Court of Appeals decisions. As I said, we're looking at the federal court structure here, and we'll look at New York in a minute. And as you'll see, each of these systems has a variety of district or trial courts. The federal system then has intermediate courts of appeal, or 13 circuits. You've heard of the Second Circuit, the Eighth Circuit, etc. Taking a look at New York, there's the New York civil court structure, and you can see again there's a variety of trial courts that feed into 4 intermediate appellate courts, or 4 departments. And then finally at New York, the court of last resort is the Court of Appeals. And just take a real quick look at the New York criminal court structure, which is very similar to the civil court. There's a variety of trial courts which feed into the 4 appellate level courts that ultimately appeal to the Court of Appeals as the court of last resort. Okay, so now we're going to move on to how do we actually find case law. And as you know, case law is published in bound volumes known as reporters. Print reporters publish cases in chronological order, and unlike most other printed legal material, there's no pocket parts or updates to cases, so they just are the opinion and then they stay static like that over time. Later opinions which alter the authority of a decision are going to be published in a later volume. So where do we find it? There's, as I said, reporters. They're supposed to official, like the United States reports. And when I say official, I mean it's been designated by statute and it's an official publication of the government. It'll either be the federal government or a state. And there's unofficial, like West Pacific Reporter, which are generally annotated. We'll talk about annotated codes next week. These are annotated case decisions, so they're kind of a combination of the primary law, which is the opinion or the words of the court, and some helpful finding aids that are provided by the West editors. So, official report is designated by statute. At the federal level, we have the United States report, and for the federal circuit and for the federal district courts, there are no official reporters. So the only place we're going to find these particular cases in print are the federal reporter, which we're up to the 3rd series now, so it's F3rd, and the federal supplement, F2nd, we're up to the 2nd series. Those are both West reporters. For New York, we do have an official reporter for each level of our hierarchy. The New York reports is NY 3rd up to the 3rd series for the Court of Appeals. The appellate division reports are AD 3rd, and then the miscellaneous report is where that whole grab bag of trial courts would have their opinions reported. West also has unofficial reports. As I mentioned, the federal reporter and the federal supplement are the only 2 available for the intermediate and the district courts at the federal level. And there are also 2 unofficial reporters for the Supreme Court. And you're all familiar with this, the Supreme Court Reporter and the U.S. Supreme Court Report Lawyers Edition. Basically, you can find the same text of the case that you could find in U.S. reports, but there would be additional finding aids, head notes, and key numbers and things like that in the unofficial versions. West, in addition to printing these federal levels, they also print regional reporters where basically they are gathering up the Supreme Court, Court of Appeals, highest court decisions from a variety of states in a regional area and grouping them into a regional report. So we have things like the Pacific Reporter, the Northeastern Reporter, and then for New York and California, they provide yet another reporter, New York Supplement or California Reporter. In New York Supplement, not only would we find New York Court of Appeals decisions, but also some decisions from our intermediate level appellate courts, and the same thing for California. So that's what the reporter system looks like. You can see it's regionally based. The Pacific Reporter contains contains a lot of the states over on the West Coast, and we are grouped with some other Northeastern states in the Northeastern Reporter, so we could find our Court of Appeals decisions in the Northeastern reports. And if you're looking for jurisdiction-specific rules, you can take a look at those pages of your Blue Book, and it'll guide you into how to cite to these cases. Okay, so imagine you're saying at this point, well, who cares? If I need an opinion, I can just go get it wherever I can find it. And you have to care because the Blue Book cares. So if you're writing something and it has to be compliant with the Blue Book has very specific rules of what reporter you cite to. So you're looking at it on Westlaw, or you're looking at it in print, that's fine, but you need to cite to a specific reporter to do a Blue Book compliant cite. So if you look at Rule 10.3, it'll tell you the preferred reporters to cite to. But what you really want to do is go to Table T1, which begins on page 233 of the current edition of the Blue Book. And it'll tell you exactly what you should do. So if you're citing a New York Court of Appeals case, it's going to tell you exactly what reporter to cite to, and I'll show you that in a minute. And you should definitely follow this for this class. Make sure that everything that you hand in writing is in Blue Book form. I do take points off for that because it's important in practice, and when you get in front of a court, you need to know how to follow a citation system. So when you cite to a case, we're still kind of pretending like we're looking at it in print. So we're still citing to a volume and a reporter and a page number as if we were looking at it in an actual printed volume. Even if we've never done that and we're looking at it on Westlaw or Lexis, that's still how you do citation. This is actually how you would cite New York Court of Appeals decision. This is exactly the correct cite, and you can see that you're not citing to the official New York reports. That's the Court of Appeals reporter that's been designated by statute, but that's not what the Blue Book wants you to cite to. It wants you to cite to the Northeastern reports only because that reporter is available more widely in different states. So that was the original theory behind that, is that a California law library would have access to the Northeast reports where they might not have access to New York reports. Be that antiquated as it may, that is still the Blue Book rule, so that's still what you need to follow. If you're citing to a New York case, go and look in the Blue Book and see what reporter they're asking you to cite to and follow that. So here I am in Westlaw. What am I going to do now? I need to figure out how to cite to this particular case. This is a second department case, which is our intermediate level. It happens to be the one that the Brooklyn jurisdiction falls in. So here's all of these various parallel cites. You can see there's slip opinion, there's a New York supplement, there's a appellate division. What do I cite to? And here's how this is supposed to appear for a New York appellate division case. You can see there's no mention that it's in the second department because that's not in a Blue Book cite, and it's not going to cite to that appellate division reports, which is our official appellate division reporter. So to find that out, I go to the New York specific part of Table T1 in the Blue Book, and I'm providing you again there with the page that it begins on. And here's what it looks like. So if I'm citing to a New York Court of Appeals case, it's telling me after 1847, cite to Northeast Second or Northeast if it's a little earlier than that. If I'm citing to an appellate division case, it's telling me to cite to NYS or NYS2D. And you can see that parenthetical, it's saying NY App Div. That's all you put in the parenthetical, plus the year. Nothing about the department. That's not what they're looking for. And if you look above in the Court of Appeals, you just put New York and the date in the parenthetical. So this is all a little ultra specific, but it's important for no other reason other than you're going to lose points on written assignments that you hand in to me if you don't have Blue Book compliant sites. So just go do it in this format and you'll be fine. Okay, so just bear with me for another minute on this citation business. I mentioned when citing to published opinions for this class, you should put them in Blue Book form. But you'll find when you get out into practice, sometimes court systems are not looking for Blue Book format. For instance, the New York courts actually do want you to cite to their official reporters, and you need to follow a certain style just like you do with the Blue Book. Unfortunately, it's just a different style, and that's the New York Style Manual, or it's called in practice the TAN book. So if you become a New York litigator and you're filing documents with the New York courts, you'll need to become familiar with that, which is kind of why I insist on Blue Book format for this class, because it's going to be important for those of you that are litigating in practice. And what about citing to unpublished decisions? Because there are many unpublished decisions, and some of them might be useful to the particular argument that you're trying to make in a court. So if you're litigating in the federal courts, the federal rule permits citing to unpublished decisions issued on or after January 1st, 2007. So that gives you a lot of leeway. And the New York rule permits you to cite to unpublished decisions in general. You can cite to them. The rule allows you to do that. Not in a reporter, what are you citing to? It says that you must cite to the most available source, which often is going to be an electronic source, maybe the Court Court website, or it could be that it was published in the New York Law Journal. So you'll have to figure that out case by case. But in the federal system, you're allowed to cite to them after January 1st, 2007, and New York, you are allowed to cite to unpublished decisions in general. All right, so now we're just going to spend a few minutes looking at what case would look like in a West reporter. As I explained, the cases in Wests are a combination of primary and secondary authority. The opinion of the court is going to be the same thing that you would find in the official reporter. It's just the language that was written by the court. But there's also a variety of editorial enhancements. There's head notes, a synopsis, key numbers, and those are all secondary authority. So you have to make sure that you understand the two and you don't go and cite to a head note or something. They're helpful for you to use to help understand the decision and to find additional relevant authority, but you don't want to cite to them when you're giving advice to a client or a partner or citing to another court. So we're just going to take a quick look at them and see what does this all look like. So here's a decision in print. Basically works the same way electronically, but this is where it all came from, so it helps to take a quick look and see how these pieces came together. So here's the parties. Those are the litigating parties. There's the citation, so that's the Blue Book compliance site to the Northeast reports for a New York Court of Appeals case. There's the parallel site. There's the New York Official Reporter. If we were before a New York court, we would use that. There's the court and the date decided, so you can tell who's making the jurisprudence. There's this concept of star paging, so while I'm in the volume of Northeast reports, I can also see where this particular page fell in New York Reporter. So when you're doing reading of cases and you have a bunch of cases, you want to try to avoid reading the case from the beginning to the end until you figure out whether it's going to help you or not. So this is one of the tools that you can use. This is a synopsis. A Westlaw editor has read the case, and then they've given you a little summary of the legal issues and the facts, and you can decide whether this is something that you want to put aside for a great detailed review later, or whether it's not going to work for you and you can put it aside and move on to the next case. And the head notes are an innovation of West that came about 100 years ago. And the idea of that is a West editor will take every single legal issue that is presented in a case and they'll summarize it in a head note. And this way you can more efficiently read the cases and see what the legal issues are that are involved in this particular case. Once the head note is written, then the editor will assign a key number subject heading to it. So the big heading is negligence, and then it's broken down into these smaller subtopics or keys. And these are really finding aids. The idea behind these keys is that if you find one head note that you find particularly helpful to your argument, you can then click on the key in Westlaw, because it'll be an electronic hyperlink, or go look it up in print, and you'll find all head notes from other cases that have been assigned to the same subtopic. So very helpful when you're trying to find additional relevant authority. So in a West decision, only here is where the actual words of the court begins, when you see this opinion of the court to tone judge, and only after that should you be citing to the opinion. The rest of the stuff is for you so that you can understand the case and find additional cases, but here is where the actual words of the court begin. And then if I was looking at this in print, West would insert the head note numbers in brackets throughout the opinion so I could see where did those head notes come from. This is what the attorney editor was reading that they created the head notes 1 and 2 from. If I'm reading this electronically, I can just click on that 1 and 2 and jump back and forth between the head notes and the language in the opinion. In print, I have to kind of flip back and forth in the pages. Okay, so moving on from the sort of anatomy of a decision, let's talk about when we're looking through a big bunch of decisions, and usually when you do a keyword search or you're finding them from a secondary resource, you have a bunch of decisions that you have to make your way through. What are you looking for in a decision before you decide that you want to rely on it? So 4 different factors. On point, which means that it's both similar in facts and legal issues. A case like this is often also referred to as being on all fours with your case. Binding authority means that it's binding on the court that's going to be considering your issue. So for example, if you're in the second department in New York, you don't really care about what some district court said in New York, and you don't care about what the California Supreme Court said. It's persuasive authority, but it's not binding authority. So you want to find a case that's binding on your court. Recent, obviously if you've got 2 decisions and they're saying about the same thing, you want to find like a 2013 decision as opposed to a 1985. but I would take that with a grain of salt because sometimes the 1985 decision is the seminal case that everybody's citing, and that's again why you want to rely on a secondary source because it'll tell you what the seminal cases are in your area. So maybe you really do want to cite that 1985 decision. But all other things being equal, you want to get a more recent decision because that will reflect the state of current jurisprudence as opposed to something that may have evolved into a direction that the 1985 court's not going to know about. And the last thing is leading case. As I mentioned, courts appreciate that you understand what the leading cases are in a particular area. And in the federal district courts and courts of appeals, that's usually going to be Supreme Court decisions that you're relying on. And in New York litigation, it's usually going to be Court of Appeals. So rarely are you going to find a case that satisfies all of these criteria. It would be great if you do, but it's good to know what the ideal is so that you can kind of sift through your results and figure out what cases are the closest to this ideal. All right, so let's spend a few minutes talking about how you actually find cases using Westlaw or Lexis, and I'm just going to give you 4 approaches. So if you have a citation, you enter the citation into Westlaw or Lexis, and you can do it right from the landing page, or you can go to a print reporter if you have that and go to the volume 690 and turn to page 854. That's just as easy. It depends on what you have available to you. You can use a secondary source or an annotated statute. We'll spend a lot of time next week talking about annotated statutes. A legal encyclopedia, a law review, a practice aid, a treatise, a blog post, all of those things are great sources to find case citations. So here's just an example of the pattern jury instructions, which are a practice tool that litigators use. Not only does it tell the instructions that juries are given in the particular cause of action, but it gives you all the various case law that's interpreted this particular cause of action. So that's a good place to go. And then Westlaw, I can just click on that hyperlink and it'll take me right to the case. I can use binding aids, which we're going to spend a good part of the in-class lecture talking about: topics, key numbers, headnotes, and digests. And that's what that looks like. So if I'm in a case, I can see, I talked a little bit about this key number. So the big overall topic is corporations, and then going down all the way to this fine subtopic, which is the piercing the corporate veil concept, or the limitation of personal liability on shareholders. If that were something I was interested in, I would go ahead and click on that key 1141, and it would give me all of the other piercing the corporate veil cases in New York, which would help me to make my argument, or at least I would be aware of the relevant cases in the area so I could kind of argue around them in front of the court. And the last thing I could do is a keyword search in Lexis or Westlaw. Either natural language, just put in piercing the corporate veil, we'll stay with that example, or I can do Boolean search, and we'll talk about Boolean searching towards the end of the semester. But just for now, if I put it in quotes, piercing the corporate veil, it's just going to search for that exact phrase as opposed to searching for each of the words individually anywhere in the decision. Or I could say something like the phrase personal liability within 3 words of shareholders. So if you learn Boolean searching, it can be very helpful because you get fewer results, obviously, but you're hoping that they'll be more highly relevant. I still do Boolean searches, and I tend to prefer them. Lexis and Westlaw have gotten much better doing natural language searching, though, so if that's what you prefer, that works as well. Here I am doing that Boolean search that I mentioned, and you can see that the results that I got, it's pulling up 37 cases, but they're all going to be exactly on point with piercing the corporate veil in New York. All right, so that's it for the video portion of this lecture. We'll do a quick research exercise when we come into class on finding an efficient reading of cases, and then we'll spend a lot more time talking about the various finding aids that are available in Lexis and Westlaw when you're searching for cases. The key number system on Westlaw and the topic search system in Lexis, and there's some other tools available as well. Firms pay hundreds of dollars a month for Lexis and Westlaw, and this is the reason why. So you want to make sure that you take advantage of all these enhanced search capabilities when you're doing case law searching, and I'll show you similar kind of functionality next week when we talk about statutes. As usual, before you go, make sure you take the week 4 quiz and submit your results. I'll see you in class.